Welcome, everyone. My name is Mario Scafaris. I'm a professor of information systems, and I am the chair of the Chook Department of Information Systems and Statistics. I welcome you to our annual spring event for alumni, students, faculty, and staff. I will speak very briefly. Before I say a few words, I want to thank my colleague, Professor Nanda Kumar, who organized this event. He's our Director of Alumni Relations in the department, among the many hats he wears. But I really want to thank him for all the work he's done putting this event together. If anything has come, if we've learned anything from the last year globally, is that technology is the essence of life. Everything we do, everything we have been doing for the last year, whether it's personal, professional, and political, has relied on the use of technology. And the information that flows through that technology, whether it's information or misinformation, whether it's information about a pandemic or a political candidate or an election or a Zoom meeting with your grandchildren, all of that is what has kept the world going in a very, very difficult year. But technology may be the essence of life, but who owns the essence of life can have quite a lot of power. So that's what we're here to discuss, to hear from 4 experts who are going to talk to us about exactly that, the power that rests in the hands of, or in the boards of several large companies that are the owners of these technological platforms that have been and will be for the foreseeable future the blood of the world. So with that, I want to pass it on to my colleague, Nissan Pakin from the Department of Law, who is kindly agreed to be our moderator for tonight. She's an expert in this area. So Nissan, the floor is yours.
Thank you very much, and thanks for having me and organizing this wonderful event. I must say, I am more of a fintech expert, so just a quick caveat, but I definitely am very interested in everything big tech related, and I think that big tech platforms power is something that we will continue exploring in the coming years, and definitely in the last year, as you point out. All of these topics have become much more interesting. And I want to quickly thank and introduce all our experts today. So we have 4 experts with us that we will be discussing these issues with and ask questions. And I want to ask everyone to type any questions that they have during the conversation in the chat so that we can periodically read the questions or see if they're urgent and not wait until the very end to address them. And of course, at the very end, we'll allocate about 15 minutes for you to ask any additional questions, but you're welcome to write them during, and we'd be more than happy to address them. So our first expert, Hannah Block-Webber, is an associate professor of law at the Texas A&M School of Law, and she studies, teaches, and writes about law and technology. And in particular, she has been looking into some of the big tech platforms, technologies and tools and methods as to how they moderate content and deal with content. She was also the supervising attorney at Yale Law School in Media Freedom and Information Access Clinic, and worked as a litigation associate at a major US law firm. Our second expert is Laura Heyman, who's a professor at the William and Mary Law School and has a great first-hand experience with some of the issues we'll be discussing today, as she actually worked as the assistant general counsel at America Online, and prior to that advised clients on these issues as a practicing lawyer and has some background in journalism as well. We also have with us Mike Masnick, who is the founder and editor of the popular TechDirt blog and website, as well as the founder and CEO of one of the leading think tanks in this field, and generally one of the go-to people for understanding these issues, and we're very fortunate to have him with us today. And last but not least, Baron Zoka, who is the president and founder of the Tech Freedom, which is a Washington, D.C. based think tank that focuses exactly on these type of tech and policy and entrepreneurship related issues. And we're also very privileged to hear from him, as he has a very vast experience in all these issues and was the former senior fellow at the Center for Internet Freedom at the Progressive Freedom Foundation, and has a rich experience litigating and practicing law as a lawyer in the telecommunication issues world. And so I want to start with Laura, and if you don't mind, we have different audiences, people from different backgrounds, all interested obviously in this very fascinating topic. But if you could start with maybe like a brief overview, 101 on Section 230, and kind of talk about what it really means, why it was created, and is it unique just to the US? What's happening elsewhere? If you could give us a little bit of background, that'd be great.
Yeah, I'm happy to do that, Nizan, and thank you again to everyone here for the invitation to participate in this panel. And I guess I should start by offering the standard disclaimer. As Nizan mentioned, I was in-house counsel at AOL for 3 years, but although my views are informed by my time there, I obviously don't speak for them or for any other employer. So yeah, let's talk about what Section 230 is for folks in the room who aren't familiar, but who may have heard that term being bandied about. So Section 230, that's shorthand for 47 USC Section 230, which is the citation to the legislative provision. And to understand what Section 230 is about, it's actually helpful to go back to the history. So if we go back to the mid 1990s, which some of us in the room remember very well, and maybe others in the room weren't even born yet, people were trying to figure out sort of the internet, how we use it, and what sort of liability sites might have for user-generated content on their sites. And it was pretty clear even then, it's definitely clear now, that what we were talking about was going to be at the kind of scale that was very different from other kinds of media, sort of physical newspaper that we experienced before, that this was going to be different. And it was also different in the sense that we've all experienced, where the content that we post, for example, when we post to Facebook or other kinds of things, was going to be more or less automatic. So we weren't expecting this idea that you would post something to, let's say, a message board or a forum. That's the kind of thing we were talking about in the 90s, and that it would enter sort of this holding pattern for some sort of review. So this was this world in the 90s, and we were trying to figure out, well, what does that mean for liability for these sites? And basically, we had sort of two takes on this, or two courts in New York that had come out with decisions on this, one involving the provider CompuServe, one involving the provider Prodigy. And their decisions related to the content moderation that these providers were doing on these forums or message boards. And basically, in one case, CompuServe was not doing moderation. And so when they got sued for a post that somebody else posted, one of their users posted on the grounds that it was defamatory, the court said, well, CompuServe isn't doing any moderation. They don't know about the content, therefore they're not going to be liable. In the case involving Prodigy, though, Prodigy was doing content moderation. And so the court in that case said, well, Prodigy is looking at these things, they're taking down certain material, and so they're going to be liable for the material that they don't take down. And so you can imagine how this actually creates some really wrong incentives. Because if the law is going to say you're going to be liable because you're engaging in content moderation, you're going to be liable for things that you leave up, well, then the incentive then is to do what CompuServe did, which is not to moderate at all. And that makes these kinds of sites not a very pleasant place to be. So Section 230 was Congress's response to this state of affairs. And it was basically Congress's reaction that, or recognition that in order for the internet to thrive and to continue to thrive and develop as the sort of basis of information exchange that we know it to be today, that a more hands-off approach to regulation was really the way to go, right? And sort of a reaction to that holding in the Prodigy case. And so essentially, the core of Section 230 says two things. So one, and this is, I think, the key part, these are the 26 words that you might have heard referred to. It says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So let me just read that one. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So essentially what that means is that a service or even a user isn't liable for another user's content. And secondly, the second provision talks about that there shall be no liability for actions voluntarily taken in good faith to take down objectionable material. And we'll talk a little bit later about the First Amendment and how that sort of reflects the First Amendment in any event. But essentially, those are the sort of key provisions of Section 230, and that interpretation was upheld in 1997 by the U.S. Court of Appeals by the Fourth Circuit in a very well-known case called Zarin versus America Online. It's been the prevailing interpretation ever since. There are some carve-outs. So if you look at the law, you'll see there are carve-outs for federal criminal law. There are carve-outs, for example, for intellectual property. But for your basic claim that, for example, content is defamatory, if that content is posted by a user, the site will not be liable for it. It'll be barred by Section 230. And I think we've seen that this has, in fact, allowed the internet to flourish. We'll talk, I think, in a minute about some of the sort of practical implications for this. But I think that, as we think about some of the reforms that people are proposing, including, for example, to eliminate Section 230, what we will see is exactly the sort of incentives that spurred Section 230 in the first place, which is to say that sites will have to make the decision about whether to essentially exist at all or to allow user content at all. I'll say one last thing and then turn it back over to some discussion. Which is that a lot of the concerns, I think, around this, and some of the concerns even at the time, were that there was a lot of awful stuff on the internet, right? And that is true. And so nothing any of us says today, will say today will minimize that. The reason there's a lot of awful stuff on the internet is because there are a lot of awful people. And so thinking about Section 230 and sort of trying to get at that problem by reforming or eliminating Section 230 isn't really getting at sort of the core of this. So that's sort of the overview. So for those of you in the room who are wondering, okay, what is this thing we're talking about? The thing we're talking about is this provision that essentially, in my view, has allowed the internet as we know it today to exist.
Thanks. And you actually made me think of Avenue Q and the Internet's for Porn song, the famous song, because obviously the internet reflects the content that people create in it. So I think that that's very helpful to kind of bridge everyone into a good starting off point. But Baron, I wanted to ask if you can continue from sort of this point and talk about the relationship between Section 230 and the First Amendment. How do we see it come into play? And also, if you don't mind, kind of maybe talk about the difference between publishers and distributors.
Sure. So that was an excellent overview. So it leaves out some important detail, and this is where people get confused. So Section 230 does two very different things. Number one, it ensures that websites, as Laura explained, are not held liable for content that they publish, that they make accessible, or that users are not made liable for that. So for example, Donald Trump actually invoked Section 230 to have a lawsuit against him dismissed. That lawsuit had alleged that he had contributed to defamation by retweeting someone else's content. So Section 230 applies equally to that as it does to any website, no matter how large or small. And it enables us all to take advantage of social media sharing functionality, which would otherwise be impossible because you could be liable for anything you reshared that someone else had said. And in that respect, Section 230 changed the common law. The common law held websites liable either because they moderated content. Prodigy promised to create a family-friendly environment and was held to account for those promises. Or in the earlier case, 1991, because a website might have had knowledge. So in that particular case, CompuServe didn't have knowledge, so it wasn't held liable. But that's how distributor liability works. If you, for example, are a bookstore, you're not held liable unless you have reason to know that the content that you're distributing is unlawful. And Section 230 said, we're going to abolish those distinctions. It just doesn't matter it creates, as Laura explained, very perverse incentives. So we're going to say that you shall not be treated as a speaker or publisher, which includes, as the courts have said, distributors as a subset of publisher liability. You're not going to be held liable for that material under civil law or state criminal law. So in other words, federal criminal law will apply, but there will still only be one controlling body of law for the internet. So that's the first thing that Section 230 does, and that's the main thing. And Section C1 very clearly does that. That's the provision that Laura read to us. But Section 230 does a second thing, which is that it ensures that websites will not be held liable for moderating content. So the first thing says that they're not held liable for the content that stays up by virtue of moderating. And the second thing says you can't be sued for moderating for your decision to remove content or hide it or otherwise restrict access to it. And in that sense, that is not a change to the common law. If you think about it carefully, that is, in my view, that is simply an articulation of what the First Amendment would have held anyway. So websites are, in my view, like newspapers. Newspapers have a right to curate the content that appears in their pages, and they can't be sued for making those editorial decisions. It doesn't make any sense to talk about newspapers censoring content because the exercise of editorial judgment is what they do all the time. Newspapers, magazines, and other media all have First Amendment rights to do that. And in that sense, Section 230, as I said, does not change the common law. It provides a shortcut. It says that you don't have to litigate those difficult constitutional questions, which could be very time-consuming and expensive. In fact, so time-consuming and expensive that many people wouldn't bother the first time they got sued, or merely because they might be sued, they would hesitate to moderate content. So Congress wanted to remove any legal disincentive. So that's a kind of tort reform, but it's one that protects free speech rights. Now, once you understand those two functions are different, I think it becomes easy to see that most people, when they talk about Section 230, get confused because they look at the text of the statute and they just assume that the two key provisions, C1, one that Laura talked about, which says you can't be treated as a publisher or a speaker of content provided by a third party, they assume that maps neatly onto the first function, which it does. But then they also assume that only the second feature of Section 230, that is C2A, which says that you cannot be sued for decisions you take to remove content in good faith that you find to be objectionable for a variety of reasons. The most important mistake everyone makes is they assume that only that provision protects content moderation. And in fact, what the courts have held very consistently since that 1997 Zeran decision is that while C2A does protect content moderation, it's a fallback provision. It provides a protection when C1 doesn't apply, but that C1 protects content moderation as well as ensuring that websites are not sued for content that they do host. And the reason is very simple. It's that to sue someone, to treat them as a publisher means, as the court said in Zeran, to hold them accountable for the editorial judgments that publishers make all the time, which includes both the decision to put content up and keep it up, and also the decision to withdraw it. So just as a website, as a newspaper can't be sued for exercising that judgment, as a publisher, neither can a website. So you see the content moderation then is protected by both provisions. And once you understand that, most of the arguments that have been made over the last year, especially by the Trump administration and supporters, just make no sense because they all focus on trying to constrain C2A and to say, well, we don't think that otherwise objectionable should be broadly interpreted and it should only protect the removal of the specifically enumerated content that is harassing or violent or whatever. And in fact, what is very clear is that Congress intended to encourage websites to exercise their editorial judgment to remove content for whatever reason, and that it would not be the proper role of the courts or the government to second guess those decisions. So in a nutshell, Section 230 merely gives effect to the First Amendment's protection of that right of editorial judgment.
Thanks. And I think that also actually addresses one of the questions that we've already had in the chat. So just to kind of tie that back to whether Twitter and Facebook have that kind of gatekeeping power. Mike, I wanted to hand it over to you and kind of ask about We talk about big tech platforms, but it's really sort of everyone, right? It's every single type of website or service out there that is covered by this section. Is this a good thing or a bad thing? And also, how practical is it to expect every single website or service out there to comply?
Yeah, it actually goes beyond that. It applies to not just every single website that is hosting any third-party content, but also to users, as Baron noted earlier, that it is the service or the user. So there have been cases, again, as Baron noted, of people retweeting someone and being protected under 230. There are some famous cases of people forwarding emails and being held protected by 230. And that's really important. So I think it's actually good to make that distinction and be very clear about it, that it protects everyone, that, there's this story out there that it is only, this is a gift to big tech, or it just protects big tech. And that's not true at all. So it protects all of us. Every time you forward an email, every time you retweet, every time you share a Facebook post or something like that, Section 230 is protecting you directly. But then the other part is also really important, which is that it is protecting all of the smaller websites as well, and protecting them in interesting ways, which in part is that it allows all of these different websites to experiment in different ways and to explore different systems or styles of moderation, and to find what works for the community that they are targeting. So, you have all of these different models. Everybody focuses again on the big companies, and they talk about, Facebook and Instagram and Twitter and YouTube as if those are the only companies that have these questions. But 230 has allowed for very different models like Wikipedia, where you have, everybody, it's just sort of this open platform in which everybody is doing the moderation. Or you have a situation like Reddit, in which you have, a whole bunch of subreddits, and each of those subreddits has different rules and different moderators, and they can do that because 230 allows them to experiment and doesn't set up a sort of rigorous compliance setup where you have to moderate in a certain way, or certain moderation decisions suddenly make you liable, which would, really constrain the ability of companies to do this. And so if you had a sort of different setup that was not like the way 230 is now, you would create a bunch of incentives that are potentially really dangerous. To one extent, you may have situations in which the compliance costs and the compliance structure is so complicated and so involved that you actually only limit the possibility of hosting third-party content to the big companies, because they have lots of lawyers and they can handle the compliance, and they can hire the expensive lawyers, and they can fight the battles, even if they're protected by the First Amendment. Like Baron said, again, it's expensive to litigate that. And 230 helps protect the smaller companies, so that they don't have to litigate those issues, which can cost upwards of $1 million or more at times. And it creates that. The other thing that having specific rules or compliance would do is really sort of homogenize the setup for content moderation, because even if, depending on, all the different reform bills are different, but depending on what you have, a lot of them involve things like best practices or specific rules. And so what would happen is, in order to avoid liability, is you would have a whole bunch of sites just saying like, okay, we're just going to follow these exact best practices, whether it's like, Facebook comes up with a set of best practices, everybody will follow that this way. If they do get sued when they go to court, they can say, we're following exactly what Facebook does, right? And so we're protected. Whereas if the way it is right now, again, you have all this experimentation, and you can do things like, one of the recent stories that was interesting is the knitting community Ravelry, right? It's a, very targeted community, but huge, millions of users, many millions of users. And they decided somewhere in the middle of 2019 that they no longer wanted anyone to be talking about Trump or the Trump administration. And that was the rule that they put out. And a lot of people were upset with that. A lot of people were really happy with it, but they can make that decision. It's their platform. They're saying, we are a community about knitting. We don't want this particular kind of content on our platform. And we're saying that. In a world in which you have different 230 rules or no 230, suddenly that becomes a potential battleground. And suddenly you have this small site that doesn't have outside investment, is run by a very small team, facing massive liability for what was, again, as Barron said, really an editorial choice, which is we don't want this on our site. In the same sense that a newspaper decides I don't want to publish this kind of content, or that any sort of private company says I don't want to have this kind of speech on my property. And so 230 is incredibly flexible for smaller companies to experiment. And out of that, you also get innovation. One of the most interesting elements of the debate around trust and safety and content moderation is the fact that, everybody is still learning how to do this. Many of the issues, Laura at the beginning said correctly, that you have bad content because you have bad people, right? That's like, that's a really important thing that seems to get missed in a lot of these discussions. But, part of that is that there are larger societal problems, huge societal problems, whether they're, questions around mental health care, whether they're questions around social safety nets, whether or not they're questions around criminal justice reform, all of these things that are out there that are big questions that governments have never been able to solve, that now we're getting a window into them because we're seeing elements of them through these different platforms. And rather than recognizing that there are these larger societal issues that no government has ever been able to solve completely, they're just saying, well, tech companies, you need to solve these large problems that the government has never been able to deal with. But the interesting thing is that, over the last, 15, 20 years or so, what's happened is all these different companies have experimented with different approaches to all of these different issues, and recognize that not one size fits all, but because you're getting this experimentation, you're also getting iteration. People are trying something, they're seeing this works for this community, this community is learning from that community, and deciding how to improve and change over time. And you can only have that, again, because of this sort of structure that you have with 230, rather than a lot of the reform ideas or systems that people are talking about, which would really lock companies in and say this is the one and only way in which you need to moderate in order to stay on the right side of the law. So I think that flexibility and experimentation is what is really, really important.
Nizam, can I just make a couple of quick points here? I know we want to keep the conversation moving, but if I can just jump in, just a couple of things that Mike mentioned. I think one thing that's also important to keep in mind, a lot of the discussion so far has been sort of thinking about what it's like from the site owners or site kind of moderators experience, right? So thinking about the community, but I think it's also important to recognize the way in which Section 230 benefits just users and participants in communities in terms of the access to information that it enables. So Mike was mentioning something like Reddit, where you can have these subreddits that where people, for example, who have certain illnesses or other sorts of conditions can exchange information with one another that could be helpful. If the site is going to be liable for information, then that won't exist. People can participate in groups, so you can think about a youth somewhere where they are engaging in questions related to gender identity. They want to engage in a discussion forum because their own community doesn't feel safe. If that won't exist, right? If Section 230 isn't there. So I think that's, to think about ourselves also just as participants in these conversations, in addition to what it means for platforms and other providers of these sites. And the second quick thing I wanted to mention also is just in terms of, I think another aspect of what Mike was mentioning in terms of experimentation is a lot of the questions or reforms that you hear purport to condition this freedom from liability on some sort of legal requirement. So it's often that, well, you can only get this immunity if you take down unlawful content, or if you, and I just want to emphasize that word doesn't, it's hard to figure out what that word means in any particular context. That's why we have a lot of litigation over these kinds of things. And to think about this question of expecting sites, and again, think about this in terms of you running your blog and having to figure this out with the comments that are appearing on your blog, whether something is lawful or unlawful is not an easy decision to make, and it's not an easy decision to make sort of ex ante. So one of the issues here, I think, is going to be that if we impose these sorts of requirements, they're going to be in situations where the content is sort of already existing and already judged to be unlawful in some way, and we're going to end up with this hindsight bias where we say, well, you should have known this at the time and you should have taken it down. But that's not how we need to be thinking about these things. We need to be thinking about them from an ex ante perspective, which is dealing with this incredible sort of scale of postings, where again, we don't expect our posts to go into a holding pattern before they go up, and yet expecting providers to be able to make these sort of determinations as to legality on the front end, I think is another important thing to think about.
I think that makes sense. I think maybe if we're already touching on this issue, maybe we want to talk a little bit about the 2018 exception and how that was a game changer in many ways because of the retroactive need to look into what was posted and kind of reevaluate everything. I don't know if whoever wants to sort of jump on that issue.
I'll jump in. I spent a year working on that. So this is SESTA. Let's remember that Section 230 is not blanket immunity, as is often said, right? It does not apply if you are responsible for creating content. So if you post something defamatory online, Section 230 does not protect you. And it is never applied to federal criminal law. So Backpage.com was the boogeyman, and rightly so. It was an evil site run by evil people that was used to promote sex trafficking online. Well, a documentary came out in early 2017 that called attention to Backpage's use of reliance upon sex trafficking for revenue. That's where all the sex traffickers went after Craigslist shut down its personals section. Well, to make a long story short, Congress moved very quickly to actually two laws that were combined with very little thought to how they intersected. And within 3 days of the law being passed, that is, of course, before it had gone into effect, before it had changed anything, the executives at Backpage reached a plea agreement because under existing law, there was already sufficient coverage of their activity to shut them down. So we didn't need SESTA to do that. And yet we passed a new law without really thinking carefully about how it would work. And it did two very different things. We don't have time to get into everything, but the House bill, which I was generally supportive of, tightened existing federal law about sex trafficking for prosecuting those who actually engage in it, and setting a standard that could be used to charge sites like Backpage. The Senate bill, SESTA, the one that this is known for, created broad new civil liability for websites that didn't do enough about sex trafficking, and that I think was very unwise. And we probably don't have time to get into details, but I would just know that these issues are complicated. And as a general matter, when people raise complaints, the first question they should be asking is, do we have an existing law to deal with those issues? In many cases, we do. If it's a criminal federal law, then Section 230 doesn't cover it today. So that's just not the issue. And as a general matter, what Congress did in enacting Section 230 was not to freeze the law in place, but merely to assert that there should be a consistent body of criminal law, and that the only way to do that is to make it federal. So we can have new federal laws, for example, about revenge porn, without touching Section 230, because Section 230 just, as again exempts all federal criminal law. So that is the way in which Section 230 really was future-proof from the start.
Can I just add a couple quick things about FOSTA? Because I think it's useful to think about. So the two things I want to add is that, one, there's now been plenty of evidence that despite all the talk about how FOSTA was necessary to protect women and to stop sex trafficking, that it has done neither of those things, and that it's created a lot of problems for them in one part because law enforcement actually used the various platforms, especially Backpage, to help track down actual sex traffickers, and multiple law enforcement agencies have since complained that it is much harder for them to track down sex trafficking because it has gone underground or has been harder to track down because of this law. And then a related thing is, if you look at where FOSTA has actually been used in courts, you begin to see some of the problems. And one example of this is that two of the companies that have been sued under FOSTA are Salesforce.com, a CRM provider, and MailChimp, sort of famous mailing list provider, neither of which are engaged in sex trafficking. But in both cases, the argument was that because Backpage used both of those services to help run its business, they are now responsible for any of the sex trafficking that may have occurred on Backpage. And it's not hard to think through that and think that that is clearly not what we should be going after. We should not be going after the, CRM software and the mailing list software that a company like this uses, but that is what is the end result of FOSTA. And we haven't seen any significant uses of the law and towards anything that actually has anything to do with sex trafficking.
I did leave out one point I just want to make really quickly. The worst thing that Backpage did was to hire a Philippines company to help it draft sex trafficking ads. Well, that almost certainly made the company responsible for the creation of that content. And that is another example of something that would not be covered by Section 230 today. So they could also have been civilly liable, but the cases that were brought about this were very badly litigated. And they created a perception that Section 230 was stopping legitimate lawsuits, when really that was not the case.
So moving from unintended consequences, I guess maybe back to how the big tech platforms or even any other types of websites or services deal with content moderation. Had I been looking into some of these technologies that they're using and the methods that range from automation and AI to all sorts of other technologies, hash-based filtering and whatnot. And I was wondering if you could share with us some of the most up-to-date methods and whether they're effective or not. What's happening in the real world?
Sure. So I think to understand why platforms are sort of engaged in the use of technology to do some of this work, the discussion has been really helpful in terms of framing the scale at which these decisions have to be made, right? For the big tech companies, we're talking about millions of decisions probably a day. And it takes an army of human workers to make these decisions. Those workers are not treated particularly well. They're usually contractors, and it's brutal work. And for a variety of reasons, including cost cutting by the companies, firms are really trying to automate a substantial portion of some of the screening decisions that go into determining whether content violates their terms of service and ought to come down or stay up. I think it's helpful to understand that before I get into how the tech sort of works or doesn't work, the policy drivers that have impelled some of this. So there are two basic things happening abroad in the main that I think are driving tech firms to adopt some of these kinds of tools. So lots of countries have intermediary liability protection. Section 230 is not the only intermediary liability protection. We see them, for example, in Europe, in South America. And what we see happening, particularly in Europe, is an effort to sort of shift the responsibility for online content more and more into platform hands. So in particular, I think the draft terrorism regulation in the EU has prompted platforms to try to automate more and more of their decision-making about what constitutes terrorist content, because they seem to be under what's soon going to be a regulatory obligation to proactively filter for that content. And other places we see are trying to get platforms to commit to being able to take down unlawful content within 24 hours. And if the time period for requiring a takedown is so short, there's really no way to do it without having technology that allows platforms to make these decisions at scale very rapidly. So those are sort of some of the policy drivers that are sort of leading platforms to turn more and more to automated technologies to do some of this work. Broadly speaking, I think there are basically three kinds of tech in play here. So the first is, and the crudest, is just regular keyword or hashtag filtering. So we've seen, for example, on Instagram, as the platform has found that different categories of posts violate its terms of service, it's employed hashtag filters to try to get those posts sort of taken down at scale. So an example of this is like pro-eating disorder content, where Instagram has had to sort of adopt different filters to try to adapt to the ways that users tag their content and try to suppress a large amount of violative content all at once. That's probably the crudest way to do it, because users can pretty easily just create a new hashtag or spell a hashtag differently. And then you've sort of gotten around the block list, right? So there are two other ways that I think platforms are trying to deal with harmful content. One is through the use of artificial intelligence. We've seen this become, I think, a little bit more prevalent over the last year. Platforms have become a little bit more dependent over the last year during COVID, as they've had to use technology more because they can't employ an on-site workforce. So they're using sort of AI mechanisms to try to predict whether content will violate their rules. And they can use this, importantly, as content is being posted. It's not simply that they're reacting to reports of content that violates the rules after the fact. So they're sort of building these tools into the filtering system for content as it's being posted by users. One of the difficulties with AI filtering is that it seems to reflect a lot of underlying biases about the kinds of content that should and shouldn't be permitted. And so while it's often sort of described as a neutral tool to enforce the rules, it's in practice very difficult to understand whether it is in fact using sort of neutral principles to enforce the rules, or whether it's biased against certain kinds of content or not. It also suffers from some accuracy issues, but by and large, it seems like this is an area where large platforms are investing huge amounts of money, and the AI is only going to get better over time, even though it's not particularly great as it is right now. The third kind of filtering mechanism, and what I think is probably the most problematic, are hash-based or fingerprint-based technologies. So this is sort of a technology that's been used in countering child sexual abuse imagery, and similarly is sort of gaining prominence in the anti-terrorist world as well, which basically takes an image that violates the law or violates platform terms of service and assigns it a unique mathematical identifier for that file. And you can then assemble a database of all of the hash values that identify these unlawful files, right? One of the issues with this is that the hash database can't really take account of any kind of context. So with certain kinds of content that are always unlawful, like child sexual abuse imagery, maybe that's okay. But there are other kinds of unlawful content that are only really unlawful in certain contexts, but might not be. For example, they're being reported on by journalists or news organizations. And a hash database really can't account for context at all, which is problematic because it has the effect of probably designating more content as violative of the rules or of the law than truly violates the law. So it tends to be a little bit overbroad. Another feature of the hash sort of filtering kind of technique that is emerging and that I think is really interesting is that we see more and more cross-platform collaboration in this space. So platforms are actually building joint kinds of databases to share information with each other about which content violates their rules or the law, and then take it down on a cross-platform basis. And this, I think, is interesting because it's sort of a counter argument to Mike's earlier point about the degree to which we want a lot of different sort of rules to flourish online. I think in the main, we have this idea that we should have lots of different kinds of online communities, lots of different kinds of moderation techniques and rules. But there are some areas in which there seems to be a huge amount of coherence, both nationally and internationally, between government and between platforms, that there are just some kinds of content that are beyond the pale. But that decision, right, that some kinds of content ought to be completely sort of removed from the internet is one that doesn't tend to be made in public view. And so it raises a lot of sort of transparency and accountability concerns about the extent to which there's public-private cooperation happening and convergence around a set of rules or principles that has potentially dramatic free expression implications.
Can I add just one quick thing to all the fantastic information that Hannah just provided? I mean, one thing in particular that strikes me, and I think it's important to emphasize, and there are going to be outliers, but in the main, sites have market-based incentives to moderate content, right? Sites want to be nice playgrounds and attract advertisers and attract users. There are obviously outliers in that regard that don't, or either don't care or want to attract a particular kind of user. But in general, they have market-based incentives to moderate, and also market-based incentives to respond to critiques of the moderation. So some of the things that Hannah's mentioned, where matching has been overbroad and removed photos, for example, of breastfeeding, for example, or other kinds of things. Those become issues, and I think reputable sites try to respond to that because, again, they have a market-based interest in doing so. They want to keep subscribers and advertisers. So I think that's an important thing to recognize too, because I think sometimes in the discussion of Section 230, there's an assumption that there's a free-for-all out there, and then there's absolutely no incentive. If we didn't have a sort of legal hammer here, that sites would have no incentive to do this kind of moderation. Do they always get it right? No. Is it complicated? Yes. As Hannah's saying, is transparency about what they do a good thing? I think so, right? I mean, I think that is certainly something that I think would be helpful for sites to do. But this is why most sites have terms of service that say what is allowed on their site and what's not allowed on their site, is because they want to set for their own users and their own sort of interests the ground rules about what kind of content is acceptable. So I just think there's an important sort of market-based piece of this that is worth remembering.
Yeah, and I actually want to add to that a little bit more. I think that it's a really important point that almost always gets overlooked, and so it's super important. But it even goes beyond that, right? The basic market-based incentives of advertisers, saying like, we don't want to advertise next to bad content. There's a separate myth that goes around that these companies don't want to do any moderation because more engagement is good. But that one, that's not true if advertisers don't want their advertisements to show up next to that kind of content. And second, these companies also recognize that if they're allowing abusive, harassing, bigoted content, that scares people off. And while it may have some initial, engagement or usage, over the long run, that scares people off and decreases usage. So there are all sorts of incentives for these companies to do that have nothing to do with whether or not the law allows them to. And so there's this myth out there, I think, that especially the larger companies, but all companies that have user-generated content have no incentive to do any moderation, and most of them don't want to do any. That is not true, and really has never been true. And so it's a really, really key point. So Laura, it's really good that you brought that up. I just want to kind of enforce it some more.
Actually, and actually some of it was a little bit discussed recently in connection with the Robinhood and Reddit situation, because of obviously the platforms hosting the hold the line messages and whatnot, and the criticism that followed. Lorraine, I think you had a follow-up comment.
Yeah,
and then
just put this in perspective. Fundamentally, I compare websites to newspapers. They have the same basic business model. On the one hand, they get the attention of viewers, and they get advertisers to fund their content. The only difference is that the newspaper doesn't have a lot of user-generated content. It only has some, op-eds and personals and obituaries and so on. But fundamentally, it's the same thing. And if you compare the situation we have today with the situation of the pre-internet era, in some ways, they're actually profoundly similar. The pre-internet era, you didn't see a lot of conspiracy theories or Holocaust denial content or general crackpottery in most reputable newspapers. Now you saw it in some because there was a market in some parts of the country for hate speech, for example. But generally speaking, the markets did not reward that kind of activity. And the difference now is there is a constituency, an organized constituency for all the cranks and crackpots and bigots, Holocaust deniers and conspiracy theorists and so on. And those people have now all coalesced and they now control the agenda of the Republican Party, which has decided that it's going to wage cultural war on big tech platforms in order to claim that conservatives are being censored. No one is being censored for sharing their views about tax rates or school choice or foreign policy or any normal conservative position. People are being moderated for posting content that does go beyond the pale. And of course, Mike is quite right. Content moderation is never perfect. Of course, there are examples of people making mistakes, but in my view, the inherently imperfect nature of content moderation has provided an excuse for the worst people in America to turn this into a culture war issue.
So I guess while we're talking about big tech companies and these platforms and the power that they have, two questions that I have here from the audience, and I kind of want to quickly mention. One, where does antitrust fit in, and how come that is not more of a helpful tool with content moderation? And the second question on big tech companies in that context is, when would we consider them big enough to almost be like a utility provider and then treat it differently as a result?
Well, I hate to go on here, but this is what my work is all about. So Lorraine Journal, 1951. So a newspaper was sued because it had refused to carry ads from local advertisers who wouldn't join in a boycott of the new radio station. And it raised a First Amendment argument. The court said, don't be silly. You're being sued for economic conduct. The antitrust laws don't protect you from that. So of course you can be liable. So in that sense, the media are not immune from the antitrust laws when the issue is the abuse of economic power and business practices. But the antitrust laws do not cover the exercise of editorial judgment. If you refuse to carry a local advertiser because of the content of their speech, you can't be sued for an antitrust violation, and the same is true here. There's just no way the antitrust laws have any application when the debate is about the nature of content that is or is not being accepted. And the same goes for utility regulation. I've written about this extensively. Even the court has recognized that even heavily regulated utilities, for example, Pacific Gas and Electric, was held to have a First Amendment right in the newsletter that it put inside the envelope along with users' bills. Being a regulated utility does not change the First Amendment analysis because utility regulation is about conduct. And the only examples that people will point to is things like, so they'll say, well, the telephone network doesn't get to block all of my content. Well, the telephone network is different. The telephone network is understood by everyone as being a passive conduit that does not edit information. And nobody blames them. That's not true. Neither one of those things is true of social media. Social media are essentially like newspapers. They publish content. People look at that content and they hold them responsible for it. And they don't say they're going to offer an unedited service. They make very clear that they won't accept certain kinds of content. So there's no way that the courts would ever uphold imposing utility regulation or common carriage or public accommodations law on social media in order to limit their editorial discretion.
And
So, sorry, go ahead, Mike.
Sorry, I don't. Quickly, just on the antitrust point, I know that this one comes up a lot, and it feels like some of the issues that people bring up and that they blame on 230 are really antitrust issues, and that's fine. Let them be debated in court and discussed as to whether or not they are antitrust issues. But the fact is that the problems around content moderation, or the things that people get worked up around content moderation, often have little of anything to do with sort of the size of the companies involved. You know, and also the sort of good thing about the internet, or the nature of the internet, is the fact that it does allow so many people to connect. So like, if you were to say break up Facebook and Instagram, which is one of the remedies that some people are pushing for in terms of antitrust stuff, I don't see how that changes any of the questions around content moderation. Content moderation questions go up and down the scale, and part of the value of Facebook is that everybody can connect to everybody on it. And so antitrust is like a different issue than related to the speech issue. And so I think that it's important to think through, like a lot of people sort of conflate the ideas, and I don't think that they're as directly connected as people make them out to be.
And I also think that, you know, people are sort of responding in this way because of the ubiquity of Facebook and Twitter in our lives. And, you know, for some people, they're engaging with these services, you know, several times a day. They're key, you know, parts of their lives. And so I think conceptually, you know, we can sort of understand why people are sort of focusing on these particular services. But, you know, when we think about Section 230 or any sort of law that purports, you know, to apply and would apply to services across the board, I think it's just really important not to let particular concerns about one provider to drive policymaking for an entire industry. I mean, that's where I think that the challenge is. And I think a lot of the sort of debate in the political sphere where, you know, Section 230 is sort of trotted out, are responding to particular perceptions or particular instances involving particular providers, as we saw when you know, Section 230 sort of became the mantra when Trump was removed from Twitter, right? So that was, you know, responding, I think, to a particular perception of a particular action. You can't draft laws that apply, you know, with the idea that they're applying only to this one action and say, but we don't need to worry about anything else. It will apply to everything else. And so I think that's, you know, as these policy and reform ideas are debated, it's really important to remember what we started out with and what we've all mentioned, which is the wide variety of services and users that would be affected by any of these changes.
Yeah, I agree. I think the fact that our former president was a very big user generating content persona is obviously something that many people think about when we discuss these issues. Two other questions about technology, I guess, and the comparison to newspapers or traditional TV. Some people are asking if the fact that, you know, big data algorithms are more relevant when we talk about social media, should that make a difference if you compare it to newspapers? I think they're referring to the newspapers of the past, because obviously newspapers today also online have some of these big data algorithms. And also, is it feasible because of tech tools to hold platforms like Twitter and Facebook today to these old standards in terms of fact checking and things like that?
I would just remind everyone of what Justice Scalia said in 2010 in a case involving video games, where the court extended full First Amendment protection to video game publishers. He said the First Amendment protections do not vary when a new medium for communication appears. Period. I mean, it's private companies get to make these decisions. The only exceptions are broadcasters, because they're licensed by the government to use spectrum. And as we've discussed, the telephone company is a passive conduit. But for example, the net neutrality rules, when those went up to the DC Circuit, the 2015 rules, then Judge Kavanaugh, before he was put on the Supreme Court, argued that they denied the First Amendment rights of broadband companies. And the court said, no, because the rules only apply insofar as the broadband providers hold themselves out as offering connectivity to the entire internet without editorial intervention. But the court said, look, if you decide to engage in editorial intervention, like Prodigy did, before broadband, Prodigy offered a curated internet experience that included removing objectionable material, so it'd be family friendly, and also removing gossip, right? Well, that sort of service clearly could not have been treated as a common carrier. And clearly was free to exercise its First Amendment rights. I mean, everyone wants there to be an answer or for the government to do something, and there just isn't. And we need to distinguish between what companies should be required to do, and accept that they just can't be required to not take down material that we want them to keep up. And distinguish between that, and then there's another level in which we can have this conversation where, of course, we can suggest better ways to do this. Of course, there's plenty of room for changing how content moderation is done. Of course, it's a good thing that Facebook has developed this oversight board to allow external review. But those are not policy or legal issues. They are questions of moral responsibility and what sort of oversight we should have in a non-governmental realm.
And just to add on the issue of algorithms, because I know it's come up a few times and it's a point that people raise, when it gets down to it, what an algorithm is it's a recommendation, and a recommendation is an opinion, and an opinion is protected by the First Amendment. And honestly, it's as simple as that. And that's important to recognize. And I know that upsets people, but part of American First Amendment principles are that we allow even bad opinions, even awful opinions. And so, the nature of it is I don't think that the courts can do anything. But again, as Barron said, that doesn't mean we shouldn't support better, moderation practices and better experimentation and more learning and figuring out how to minimize harms and all of those things. I think those are all important. But again, and as Laura pointed out, a lot of that needs to be market driven. And not driven by law, because it can't under the First Amendment, at least in the US.
For argument's sake, I'm just going to adopt a contrarian position. And I'll say that, I think as a matter of law, both Mike and Barron are completely right. But there's something very frustrating about it. And what's frustrating is that the major platforms like Google and YouTube and Facebook and Twitter present themselves as not curating their services to some extent. So I know I see you shaking your head, right? But to the extent to which platforms actually do say, this is all you, it's all the users driving what's on our platform. We're just here to serve it to you on a platter. And at the same time say, we don the mantle of editorial discretion to curate and filter as we see fit, and it's fully protected by the First Amendment. Doctrinally, I agree. The platforms are completely protected by the First Amendment, but there is something very unsatisfying about the willingness to stand on both sides of the editorial line. I do want to say, though, it's never been the case that we only give First Amendment rights to those who edit or curate in the right way, right? So the fact that platforms are using new technologies to do this work doesn't remove them from the umbrella of the First Amendment, just like their failure to fact check doesn't remove them from the umbrella of the First Amendment. I think that's completely right. It doesn't mean that I'm thrilled with the prospect that the only source of sort of regulatory intervention here is the goodwill of the major firms of the world. I think that you can acknowledge that this is the legal landscape in which we reside and still feel somewhat frustrated that there's not much of a democratic voice outside of the market process for normal people to try to persuade platforms to do something a little bit different. And it is what it is, right? But I want to push back to the extent that this is like, I don't feel super optimistic about it. And I think in that respect, I may be I'm in a slightly different position from the rest of the panelists. So,
well, let me put it this way. The First Amendment is inherently frustrating. Everybody wants the government to do something, and it says Congress shall make no law, ... I mean, that's the fundamental problem. Now, I will say two things. Number one, of course, websites hold themselves out as offering edited services. That's what the community standards are all about. They all make clear that they have those standards. And what Hannah is putting her finger on is that there's no satisfying way to say we create a forum for discussion while also saying, as they do, that some kinds of expression are antithetical to civil, rational discussion, right? I mean, just try holding a large public discussion in the real world outside and see how that goes. It is an impossible balancing act. But the second thing I'll say is the First Amendment is, what is the line? The Constitution is not a suicide pact. The First Amendment, while I think it does absolutely protect the right of websites to take down content that they do not want to be associated with, there is a second debate that we could be having here and should be having. This is the one that Democrats primarily want to have, which is, well, what can we do about certain kinds of problematic content? And there, I think there is some room, not much, but some room for us to have a civil conversation, a rational conversation about, for example, updating the standard for incitement. The standard for incitement is set forth in Brandenburg is essentially impossible to satisfy online because it requires essentially someone being in front of a crowd and saying something to them that incites direct, immediate action. So it is possible that Congress could write a very tightly worded law that could make individuals responsible for online incitement. It is also possible that certain kinds of misinformation could be actionable. There's not much room there. The court recently decided a case called Alvarez, where they said that false speech is protected speech, but they did note that there are certain areas where the law has been crafted to deal with that. So, for example, perjury. So false speech about elections is a particularly good example. I think it might be possible to craft targeted remedies there, but even then, it would be one thing to ban speech by individuals. It would be more difficult to put a private company under the legal responsibility to decide where the lines should be drawn. My view is those lines should be drawn by courts. And if somebody engages in unlawful speech, that person should be punished. And if there's a court order saying that speech is unlawful, then that should be taken down. And that is a kind of reform of Section 230 that I could support.
I also just want to add, just in response to Hannah's point, which I think is right in the sense of yes, this is unsatisfying, and sort of seeing the amount of misinformation and harm that some people can cause online, I think, is important to recognize. And what's interesting, I think, is Hannah was talking about sort of, well, where is the sort of push coming from? Where's the impetus? And I think what we're starting to see, and I think it's an important move, is maybe the same sort of thing we were seeing sort of over in the copyright world, where for a long time the conversation around copyright had been driven by big content providers and content creators like Disney, and there wasn't really sort of coalition built around fair use and those kinds of things. And that's changed now, right? Where that's really a part of the conversation, and there are sort of best practices that develop and all. And I think we're starting to see that now in this realm with things like the Cyber Civil Rights Initiative and other groups. While I don't necessarily agree with sort of all their points towards Section 230 reform, the idea that there are spotlights being shown on some of the content that's there, and the harm that it causes, and the ways in which people are sort of asking or even demanding Facebook to do better in terms of the things that it does, not suggesting groups or sites to people. I think that's an important move, and I think it gets back to the point we started with, which is how do we solve social problems? And sometimes we solve social problems with the law, and sometimes we solve social problems by social reaction and social movement. And this might be an area where that second piece of it is going to be critically important to maybe getting to the kind of world that we want.
Yeah, I think to jump in on that, I think Laura's exactly right again. And actually, Hannah, for saying that you were disagreeing with us, I think we actually still kind of agree. The answer is unsatisfying, but part of the reason the answer is unsatisfying is that all of these social problems are not easy to solve because nobody's solved them yet. And I can see also in some of the comments that people are asking, people feel very unsatisfied by this. And that's a proper response. It's a natural response, and it makes sense. But the idea that saying like, well, there must be a solution is like, okay, how do you solve all of these other issues as well? How do you solve mental health issues and poverty issues and a whole wide variety of other issues? There are a ton of trade-offs with every decision. And we're dealing with, when we're talking about like disinformation online or something along those lines, this is a new issue that these companies are trying to figure out on the fly at massive scale, in which just a few mistakes, which are always going to happen just because of the sheer scale and size and the number of decisions that are being made every day, you know, everybody is trying to improve on these things. They're all, doing different things. They're coming up with best practices. Everybody's trying to figure out different ways to do it. The idea that somebody has to step in and say, solve this now, is an impossibility. You're asking to hold back the tide. You're asking to, solve poverty in a second. That it doesn't work that way. It would be nice if it did. And I understand that it's frustrating and we would all like to solve these issues, but saying like, this is unacceptable. Okay, but there is no easy answer here. You're dealing with every decision that you make, and every option that these companies face and that lawmakers face involve significant trade-offs. And a lot of what we're talking about here is sort of recognizing that every possible approach to this creates all sorts of other consequences, and nobody's going to be happy with those consequences either. So I think, coming at these issues with a bit of humility and recognizing that there is no easy answer, and that all of these solutions, there are definitely going to be ways to improve, and we're all learning what those are. But saying this has to be solved now is not a realistic stance to take.
So I guess we're getting close to the end of our time. So just two questions that I have here, and then if anyone wants to post their last question, please do so. So one question refers to defamatory content, and what can you do to effectively get rid of it or remove it or deal with it? And then the second thing is going back to something we mentioned briefly, the democratization of trading and financial services, and that in combination with online platforms and speech that is not moderated. What can we do with regards to that? I think it sort of goes back to what Mike said about can't solve everything right now, but whoever wants to try and answer.
Hannah, do you want to talk a little bit about what you see are sort of best practices in terms of moderation? The extent there is such a thing.
Yeah, sure. It's hard to say what a best practice looks like in an era where the criticisms have been so sharp all around, right? So I think one sort of interesting and probably positive development in the last year or so has been the escalating use of warning labels and sort of non-takedown kinds of remedies for harmful content online. So we see sort of Facebook and Twitter attaching labels to content that's at the edge of their sort of terms of service rather than simply taking it down. I think what we're seeing is a bunch of different experimentation, basically, with the different mechanisms by which platforms can shape discourse without sort of being seen to be censoring it. And by censoring, I just mean limiting it, taking it away from the public sphere. Of course, the problem is nobody likes these labels, right? Everybody hates them. Everybody thinks it's almost as bad, it seems like, to attach a warning label to a post as it is to take the post down to begin with. You see a similar sort of backlash to Twitter's intervention to ask whether you've read an article before you retweet it. Oh God, what an infringement of our rights that I should be asked whether I've read the article before I tweet the link. But people seem to really hate this kind of intervention. And it's interesting because it suggests to me that what's happening is the more visible the platform choices become, the more polarizing they are. Whereas when platforms just sort of take stuff down and you never see it in the first instance, yes, there is like a widespread flourishing of conspiracy theories as to why it's disappeared or never showed up, but it doesn't seem to stimulate the same kind of backlash. So that's why I think it's a double-edged sword. Some of the most interesting and I think helpful interventions here also tend to be really polarizing. And to the extent we are looking to the sort of market-based solutions to drive what platforms are doing and how they're responding to these issues, I think the jury's out on what the user base really wants and how platforms are going to respond to that.
Yeah, I'll just add a couple things to that. I think that's exactly right. And also part of the issue. So two quick things. One is that sort of as this space has sort of professionalized and developed, we are getting more sort of professionalization and more standardization and best practices. And there are new groups, like there's a Trust and Safety Foundation. There's this new Digital Trust and Safety Partnership, which is around creating best practices for these companies. And there are a few other efforts along those lines. So I think some of that is happening. But part of the issue, which I think Hannah just made really clear, is that there's never going to be any agreement. You know, to a most extreme level, whoever's content is moderated in any way, whether it's putting a fact check on it or whether it's taking it down or blocking or whatever, they're always going to be upset. And the people who support that content are always going to be upset. So you're always going to have some element of the population that's upset. And it actually becomes even more difficult. A few years ago, we ran a sort of live event at a content moderation conference with over 100 content moderation people. And we had them go through 8 different case studies and ask them how they would moderate. And they had a vote on their phones. And we gave them 4 different choices: leave up, take down, what did we say? Oh, put a content warning on it, or escalate it. Basically, I have no idea what to do, send it to somebody else. And on all 8 case studies, we had people who selected every one of those 4 things. And this was a group of professionals, you know, content moderation professionals and experts, and nobody could agree there. Nobody's going to agree on these things ever, right? And so you're always going to have some pushback and some complaint, and somebody's going to say, this is not how I would moderate it, and therefore it's bad and wrong. And so it's important to recognize that, like, you know, as we're learning new ideas and professionalizing it, it is improving. People are working these things out. It still has a long way to go, and people will continue to experiment. But the idea that we're ever going to get to a point that everybody agrees that this is the proper way to moderate is also just not realistic, because people are always going to disagree. And one point, because I saw it come up in the comments, which I hadn't seen earlier, but I think is important to respond to. Somebody said, "Oh, just remove the ability of people to be anonymous." This is a solution that comes up a lot, and in practice has not been shown to work. It's like, it's the opposite of working. There's actually a study. It's you can find it somewhere. I'll dig it up at some point and I can send it to people if people want to see it. That said that people using their real names actually turned out to be more trollish and present more bad behavior than people who were anonymous. And when you take away anonymity on these services, you also cut off all sorts of people who are at risk, are in minority groups, people who are targeted, often have very good reasons for being anonymous and want to protect themselves. And when you take away that anonymity, you take them out of the conversation, and you often do a lot of harm to those people. And so there's a real risk factor there. And so almost every sort of simple solution has a lot of consequences and downsides that it's really worth thinking about, or talking to various experts who have gone through this and studied these things. You know, there are no simple solutions. It's just like the one thing I want to keep repeating to people. There is no easy answer here.
Well, if I may, I think we will see an increased degree of decentralization to some extent. Twitter is experimenting with a platform called Blue Sky, which would allow communities to be formed essentially within a larger social network platform that would have their own, to some degree, their own content moderation standards. This would be more like Reddit, where Reddit today is not actually a single community, it is a community of communities. And I think that's largely a good thing. But I would note 2 things about it. Number one, it's going to lead to some degree of diversity of approaches only on some issues. Twitter is still going to take down the most egregious content, not just the unlawful content, not just incitement of violence, but also things like hardcore hate speech and Holocaust denial and so on. And so to the extent that complaints are really about wanting to keep that up, which is what a lot of this is really about politically, that technological change is not going to satisfy people who want these social media to be weaponized as a political tool. And if you read, for example, I'm just looking at this today, the lawsuit that was just filed by John Matzey, the former CEO of Parler, against the company and Rebecca Mercer, it is fascinating because it tells the inside story of Parler, and that John Matzey tried, in his words, in early January after the insurrection, he tried to institute some degree of content moderation along the lines that other companies do. And Rebecca Mercer wasn't interested because Rebecca Mercer's objective, this is of course the Trump mega donor, was to use the site as a political weapon to benefit a particular kind of nationalist, revenge-based, resentment-based politics. So those people will never be satisfied. That's point number one. Point number two is that Section 230 in this world actually becomes more, not less important. And that is because Section 230 protects anybody who moderates content, not just the site operator. We keep talking about big tech, but in fact, as we mentioned before, Section 230 protects users, it protects the companies, and it protects anybody else who might moderate content. So editors on Wikipedia, community moderators on Reddit, the operators of pages on Facebook, and then also in this vision that Twitter is proposing, this framework where you'd have communities that operate differently, the people in those communities who make decisions would need absolutely the protection of Section 230 against being sued. Because while it's one thing for Twitter to have to bear the risk of being sued for content moderation decisions, it would be absolutely crippling if you could be sued for making these sorts of moderating decisions within your community. So I would just close by saying that whatever happens in the future, the core of Section 230 is exactly right and needs to remain in place if we hope to enable private websites to do what fundamentally the First Amendment forbids the government from doing. We cannot require, as Europe has done, websites to clean up the worst content, like Holocaust denial. We have to do what we can to remove the legal threat that would discourage moderation of that content.
Any final remarks from everyone else, or? So I think this has been wonderful, and I want to thank everyone for coming. And Baron, you ended on such a high note that it really is a very tough act to follow. So I again want to thank everyone for joining us, and to our four experts, our panelists. Thank you very much for sharing all these really illuminating insights. And I think we'll be discussing these issues certainly under this administration, as some of the initiatives and reforms will continue to unfold and be discussed. And unless Maurice, you want to add something, we'll just do a virtual round of applause.
No, I just want to add my thanks as well. This was a fascinating discussion. It was it was like being at a salon watching people discuss a really interesting topic. So I really want to thank you all.
Thanks for inviting us.
Thank you.
Have a good night, everybody.
Thanks.
Thank you. Bye bye.
Have a nice day. Bye bye.